You are the co-chair on this, so you want to take over?
Thank you, Diane. Good afternoon, everybody. My name is Scott Greaves. I'm a partner with Greaves and Rothler Law Firm and a member of ACBC. I represent consumer debtors in bankruptcy. As Diane said, today's program is going to focus on the Americans with Disabilities Act and small bankruptcy firms. As most of you know, all attorneys are likely to encounter clients with decision-making capacity that has been diminished due to a disability, and also clients with physical disabilities. Clients with diminished capacity will have unique needs and require accommodations within the attorney-client relationship. Today's program will provide you with information about the ethical rules related to representing clients with diminished capacity and provide strategies to address ethical concerns when you represent such clients. Our program today will also give you information about requirements under the Americans with Disabilities Act to ensure the accessibility of legal services for clients with physical disabilities. You will also receive tips and strategies to ensure that your services are accessible for people with physical disabilities. As Diane mentioned, today's presenter is Asim Dietrich. Asim is an attorney at Disability Rights Arizona. That's formerly the Arizona Center for Disability Law. He advocates for the legal rights of people with disabilities. His work includes representing people who have experienced abuse, neglect, and discrimination due to their disabilities, and people who have been denied medical and mental health services. Asim presently serves as the supervisory attorney for investigations, monitoring, and accountability. He also coordinates Disability Rights Arizona's protection and advocacy for individuals with mental illness program. So everybody, please welcome Asim Dietrich.
Oh, I neglected to tell you, Asim is having problems with his camera, so he's going to be incognito, but he will be operating his slideshow. So we're sorry for that, not being able to see his face. So go ahead, Asim.
Okay, my apologies. I was on mute. Thank you, Scott and Diane, for your introduction. So as Scott mentioned, today I'll be discussing representation of clients with diminished capacity, as well as talking about ensuring physical accessibility for clients. So first, I would just like to share a little bit about Disability Rights Arizona. Our acronym is DRAZ, and we're Arizona's designated protection advocacy organization for persons with disabilities. So we're a nonprofit law firm that assists Arizonans with disabilities to promote and protect their legal rights to independence, justice, and equality. And we envision a society where people with disabilities enjoy full acceptance without barriers. So DRAZ advocates for the rights of people with disabilities to be free from abuse, neglect, and discrimination. And our work includes providing information and technical assistance, as well as referrals to assist people with disabilities and self-advocacy. And we also investigate incidents of abuse and neglect of people with disabilities. So our learning objectives today is our brief discussion of the ethical rules when representing clients with disabilities who may have diminished capacity. Then the basic requirements of Title III of the Americans with Disabilities Act, reasonable modifications under the ADA, as well as physical accessibility under the ADA. So first, we'll discuss allocation of authority under the rules of professional conduct. So ethical rule 1.2 states that the lawyer is required to abide by the client's decision concerning the objectives of representation. The lawyer is required to consult with the client regarding the means by which the objectives are pursued. The lawyer may take action on behalf of the client as impliedly authorized to carry out the representation. And the lawyer must abide by the client's decision whether to settle a matter. Ethical Rule 1.4 requires that the lawyer must inform the client of any decision or circumstance when the client's informed consent is required, and reasonably consult with the client about how the client's objectives are to be accomplished. Rule 1.4 continues that the attorney has to keep the client reasonably informed of the status, about the status of a matter, promptly respond to the client's reasonable requests for information, and explain the matter to the extent reasonably necessary to allow the client to make informed decisions. So, ethical rule 1.14 and deals with clients who may have limited capacity, and it sort of provides guidance regarding the allocation of authority and communication with clients who may have diminished capacity. So rule 1.14 requires the attorney to maintain a typical attorney-client relationship with the client as far as reasonably possible. So as far as reasonably possible, when representing a client with a disability, as attorneys were required to maintain a typical attorney-client relationship with clients who may have a disability or diminished capacity. And information related to the representation of a client with limited capacity is protected by attorney-client confidentiality. So the attorney-client confidentiality applies to clients with disabilities and limited capacity the same way it does to any other client. And then this is just some information providing the comments for Rule 1.14. So a lawyer may take reasonably necessary protective action for a client with limited capacity, but only if the client is at risk of substantial physical, financial, or other harm, unless action is taken and the client cannot adequately act in their own interest. So if those requirements are met, the attorney can take protective action. And protective action includes things like consulting entities that have the ability to protect the client, or seeking the appointment of a guardian ad litem, conservator, or a guardian. And protective action that includes a deprivation of rights, such as guardianship or conservatorship, should be a last resort. And then some comments to Rule 1.14. A client with limited capacity often has the ability to understand, deliberate upon, and reach conclusions about matters affecting the client's own well-being. So a client who has limited capacity due to a disability is often still capable of making decisions regarding the representation and the matter that the attorney is assisting them with. They just may need some accommodations, such as providing information in a more simplified manner, using more simplified language, and also just providing additional explanation about the consequences of any decisions they might make. And the fact that a client suffers a disability does not diminish the lawyer's obligation to treat the client with attention and respect. So the same rules regarding communication apply to clients with disabilities, and the same requirement to provide the required attention to their matter applies to clients with disabilities. And again, lawyers treat clients with limited capacity like typical clients, particularly in maintaining communication, even if the client has a legal representative. And maintaining communication, there may be a greater requirement, an enhanced requirement to maintain communication with a client with limited capacity, because they may need additional explanation regarding their matter so they can make informed decisions. So Rule 1.14, the comments continued. Even if a client has family members or others participate in discussions with the lawyer is required to look to the client to make decisions on the client's behalf. So it's ultimately the client's decision that should be given primary consideration, and the lawyer needs to look at what the client decides, or what the client's wishes or needs may be, even if others participate in discussions. So that was just some brief information on representing clients with limited capacity. So now we'll switch over to a discussion about the Americans with Disabilities Act and physical accessibility. So first, the definition of disability under the ADA. It's a physical or disability is a physical or mental impairment that substantially limits one or more major life activities. Having a record of such an impairment is also considered a disability, and being regarded as having such an impairment can be considered a disability. However, that last prong does not apply when someone requests a reasonable accommodation in employment. So some examples of major life activities. This is not an exhaustive list, but these are some of the examples that the ADA provides. So seeing, hearing, communicating, speaking, lifting, or walking can all be considered major life activities. And then major bodily functions, such as neurological functions, brain functions, the immune system, the circulatory system, the respiratory system, and the digestive system. And again, this is not an exhaustive list, but basically any impairment that causes a substantial limitation in one of these activities would be disability. And then invisible disabilities. So any mental or psychological disorder, such as an intellectual disability, emotional or mental illness, and learning disabilities are invisible disabilities. They're not readily apparent to individuals, but they're still considered disabilities because a diagnosis is a disability if it substantially impairs the ability for a person to perform a major life activity as compared to most in the general population. So if that's the case regarding the individual's impairment, then they do have a disability under the ADA. So Title III of the ADA applies to public accommodations, so private businesses that provide services to the general public. So the requirement under Title III of the ADA is that no person with a disability can be discriminated against because of their disability by anyone who owns, leases, or runs a place of public accommodation. So it just doesn't have to be an owner. It can be anyone who leases or runs a public accommodation in the full and equal enjoyment of the goods, services, and programs of any place of public accommodation. So basically, people with disabilities cannot be discriminated against by a public accommodation due to their disability. And places of public accommodation, this is a very, very broad list of places that could be considered public accommodations. And again, it's a non-exhaustive list. So some examples are the professional office of a healthcare provider, a hospital, or other service establishment, a service establishment, including the office of a lawyer or accountant. So a lawyer's office is considered a place of public accommodation, a place serving food or drink, a place of exhibition or entertainment, or any retail establishment. And basically, any establishment that provides goods or services to the general public and is privately owned is considered a public accommodation. And then whether or not home offices are considered a place of public accommodation, I think specifically applies to the legal profession and those sole practitioners who may see clients in the home office. So the ADA provides that when a public accommodation is located in a private residence, the portion used exclusively to operate the public accommodation, or the portion used both for the public accommodation and for residential purposes, is covered by the ADA. So if you're a sole practitioner who has a home office, any area of your home that is used exclusively for that home office, or is a combination of a residential purpose as well as a purpose for your work, that those areas would be covered under the ADA. So an example could be if you designated a room in your home specifically to meet with clients and provide client consultations. That room would need to comply with the requirements of the ADA and would need to be accessible in compliance with those requirements. If there's a restroom that's a private restroom, but you also make it available to clients, that restroom would also be covered by the ADA and would need to be accessible under the requirements of the ADA. And the portion of the residence used exclusively as a residence is not covered by the ADA. So for example, a bedroom where you would never have clients, that's still considered your private residence and is not covered by the ADA. So the portion of a residence used as a public accommodation includes the homeowner's front sidewalk, if there is one, the door or entryway into the residence, hallways, and then any area of the residence available to or used by clients, including restrooms. So when you do have a home office, any area that you might make available to clients or allow clients to use would need to be accessible under the requirements of the ADA. And then just some additional information about what is considered discrimination under Title III of the ADA. So the denial of participation or benefit from goods, services, programs that may be offered to the general public. A denial of equal participation or benefit from goods and services that are offered. Providing goods and services that are separate from or not equal to goods and services provided to people without disabilities. So basically segregating people with disabilities is considered discrimination. And failure to provide good services, advantages, and programs to people with disabilities in the most integrated setting possible is also discrimination. And then imposing eligibility criteria that tends to screen out people with disabilities from the full and equal enjoyment of anything a public accommodation offers to the public. And then discrimination also includes the failure to make reasonable modifications in policies, practices, or procedures to afford people with disabilities full and equal enjoyment of anything the public accommodation offers to other people. One of the more obvious examples is individuals with disabilities who have a service dog. So your office or your firm may have a no pets policy that no one is allowed entry into the building with their pets. So a reasonable modification in a no pets policy would need to be made for individuals with a service animal due to a disability. So someone with disability who needs to be accompanied by a service animal would be entitled to that modification in the no pets policy. And then discrimination also includes a failure to provide auxiliary aids and services when they may be necessary to allow people with disabilities to fully and equally enjoy anything offered to the public. So auxiliary aids and services are basically aids and services that can facilitate communication. So providing documents in large print or braille, providing a sign language interpreter if you're meeting with a client who's deaf and uses sign language, using augmentative communication devices if someone has a speech or communication disability. Those kinds of things are considered auxiliary aids and services. And then related to physical accessibility, discrimination includes the failure to remove architectural barriers and communication barriers that are structural in nature in existing facilities, and the failure to make new facilities accessible to persons with disabilities. So the failure to do that is considered discrimination under the ADA.
Asim, before you move on, we did have a question about, let me go back to Jim's question. Jim Kahn says he's recently seen signs excluding emotional support animals from places of public accommodation. Do you think that's valid?
So Title III of the ADA specifically defines service animals, and emotional support animals are not service animals under Title III of the ADA. So a public accommodation is able to exclude an emotional support animal if the animal is just for emotional support. If it's a service animal that's providing a specific task to assist the individual with their disability, that's considered a service animal, and service animals cannot be barred from public accommodations.
Okay. And then Scott Hyder goes on to ask about if a hearing impaired person requests me to pay for a sign language interpreter, is there some other accommodation I can suggest, such as a meeting on Zoom via Microsoft Teams, which can use AI to simultaneously transcribe our conversation or use a chat feature?
So when looking at issues related to effective communication, the ADA does require the primary consideration being given to the preferred accommodation. So if someone does prefer a sign language interpreter, primary consideration should be given to providing a sign language interpreter. If that's something that just cannot be provided or is impossible to provide, then you can explore other accommodations with the individual, as long as you are providing effective communication. So that's the requirement, is to ensure effective communication. So many people who use American Sign Language to communicate are not proficient in written English, because written English and sign language are two completely different languages. So in that case, sign language may be the only way to provide that effective communication. So again, primary consideration does need to go to the client's preference, because they're the most knowledgeable about the type of communication that is most effective for them.
Okay, and we have another question about websites, but let's hold that till you get to the end. All right,
Okay. So I'm not going to go over all of the accessibility standards for physical accessibility under the ADA because it's a very exhaustive, the ADA accessibility standards are very exhaustive standards and basically cover almost any situation you may encounter. So I'm just going to provide some information about which accessibility standard applies when. And then also I have links to the accessibility standards for your own reference. So there are two sets of accessibility standards. The 1991 ADA standards for accessible design, as well as the 2010 ADA standards for accessible design. So the 1991 standards cover new constructions and alterations when the building permit application was submitted before September 15th, 2010. If there was no building permit required, the 1991 standards apply when construction or alteration began before September 15th, 2010. And then there's an option, new construction and alteration standards can comply with either the 1991 or the 2010 standards if the permit or the construction it was between September 15th, 2010 and March 15th, 2012. So between those two dates, it's the public accommodations option whether to use the 1991 or 2010 standards. So if there was new construction or an alteration between those dates, it could comply with either one of the standards and be considered ADA compliant. And then new construction alterations are required to comply with the 2010 standards if the permit application was submitted after March 15th, 2012, or if no permit was required, the construction or alteration occurred after March 15th, 2012. So if construction or alteration occurred after that date, it must be compliant with the 2010 accessibility standards to be ADA compliant. And then, so these are the links where you can find the accessibility standards. So I've included a link to the page that discusses the standards and provides a brief introduction. And then I've included a link to both the 2010 standards and the 1991 standards. So, you know, these are important documents to review to make sure that your facility or your office is accessible for clients with physical disabilities. Another thing I would suggest is if you are concerned or you have received complaints from clients with disabilities, it may also be helpful to hire an ADA consultant. I can't endorse anyone, but there are several ADA consultants that are currently available. So if concerns have arisen regarding the accessibility of your offices, it's always a good idea to contact an ADA consultant. And then a brief explanation of alterations. So new construction is self-explanatory. It's a building or facility that's being newly constructed. But alterations have a specific definition, and there are specific requirements related to alterations. So public accommodations that began alterations after January 26, 1992 must ensure to the maximum extent feasible that the altered portions of the facility are accessible to people with disabilities. So any alterations after that date must be accessible to people with disabilities. But that only applies to altered portions of the facility. And this is a list of different types of alterations. Again, this is a non-exhaustive list, but these are just some examples provided in the ADA regulations. So alterations are things like remodeling a facility, renovation, rehabilitation, reconstruction, historic restoration, changing or rearranging structural parts or elements, or changes or rearrangement in the plan configuration of walls and full height partitions. So those are some examples. And then things that are not alterations, normal maintenance, re-roofing, painting, or wallpapering, asbestos removal, changes to mechanical and electrical systems are not alterations unless they affect the usability of the building or facility. And then the requirement for alterations does state that altered portions have to be accessible to the maximum extent feasible. So this particular phrase applies to the cases where the nature of an existing facility makes it virtually impossible to make sure that an alteration complies with accessibility standards. So when full accessibility is virtually impossible due to the nature of a facility, it's not required that the facility fully comply with the accessibility standards. So in these types of cases, the alteration would still need to provide the maximum physical accessibility that is feasible under the circumstances. And any alteration that can be made accessible is required to be made accessible. And then just some information about the removal of architectural and communication barriers. So even if a facility is older than 1991, when the ADA came into effect, the ADA does have a requirement, even for older existing facilities, that architectural barriers and communication barriers that are structural be removed, even in those existing facilities that may predate the ADA. And this is required when barrier removal is easily accomplishable and able to be carried out without much difficulty or expense. And it's always best to err on the side of caution and remove the barriers they can be removed because usually, whether barrier removal is easily accomplishable or can be carried out without much difficulty or expense is usually determined by courts. So it's better to avoid that situation where a lawsuit might arise, and make sure that your facility is as accessible as you're able to make it. So some examples of barrier removal are installing ramps, making curb cuts, rearranging furniture, putting raised markings on elevator buttons, widening doors, installing grab bars in toilet stalls, raising toilet seats, creating accessible parking spaces. And I included the citation related to barrier removal for more examples. So some resources that are available and very helpful. The Department of Justice ADA website has an ADA primer for small businesses. So that can be very helpful if you're part of a small firm or a sole practitioner. There's also a document providing information about tax benefits for making businesses accessible, and that's available on the IRS website. There's many people may think it's cost prohibitive to make their business accessible, but there are tax benefits available to help defray those costs. And in the end, it could be lucrative to make sure your business is accessible because it would expand your client base, and clients with disabilities would feel welcome because they would know that your business is accessible. And then there's also a complete listing of technical assistance materials regarding Title III of the ADA. So there are a number of different technical assistance materials developed by the DOJ that can give you information about strategies on ensuring accessibility. And then also our website, disabilityrightsaz.org, is a great resource. We have a lot of great resources providing general information about accessibility that might be helpful. Okay, so that's the end of my PowerPoint. So we can open it up to any additional questions at this time.
Okay, thanks, Asim. We really appreciate all that great info. There are some follow-up questions in the chat. One of the follow-up questions is regarding interpretation for clients. Is it a violation of the ADA to not hire and pay for an interpreter?
I think again that depends on the needs of your client. If their main way of communication and their preferred method of communication is American Sign Language, and they're not proficient in written English or reading captions on a Zoom meeting, then you would be required to provide that American Sign Language interpreter. And the requirement is that you, if you determine that an interpreter is necessary, it needs to be a certified legal interpreter. And you can, there are multiple interpretation agencies in Arizona. So when you request an interpreter, you would just request a certified legal interpreter. So basically, if effective communication cannot be provided in another way, then it would be the law firm's or in the case of sole practitioners, the attorney's responsibility to provide for that interpreter.
If someone requests a sign language interpreter, are you allowed to ask them if a different method is usable for them?
You can ask them if a different method is usable, but again, primary consideration has to be given to their preferred method of communication. So if the client does seem reluctant about using another communication method, or just is uncomfortable with that, then again, the best thing is to hire that sign language interpreter.
And then another question in the chat was about websites. So what kind of things can we do with our websites to make sure they're ADA compliant?
So a lot of websites and web like web development services have professionals that can assist you with making sure your website is accessible. So I think it's important if you are having a website developed and using a company to develop that website for you, just ask them to verify that it is accessible and compliant with ADA requirements for web accessibility. And if you're using a website or building your own website, there are also a number of publicly available tools and guides that many that don't cost anything, that can provide you guidance on making sure that your website is accessible. So yeah, just consulting resources related to web accessibility, I think is the best way to make sure that your website is accessible.
If anyone else has any questions, feel free to open your mic and ask away.
One thing also I would mention, so all of the applications included in Microsoft Office and many other Microsoft applications related to developing documents all have accessibility tools built in, so you can check the accessibility of any documents you develop, and then make the modifications that the program informed you should be made. And that's also available in Adobe Acrobat. So when you are developing websites or documents, there are a lot of readily available tools that you can use as well.
We've got another question in the chat. What are the penalties for failure to comply with the ADA? And where should consumers go if they have a complaint?
So the penalties really depend. So there are a couple of ways to enforce the ADA. An individual can either file a lawsuit against the organization that may not be in compliance, or they can file an ADA complaint with the U.S. Department of Justice, or they can file a complaint under the Arizonans with Disabilities Act with the Arizona Attorney General's office. So those are a few options for enforcement. And again, the penalties, if the issue does result in litigation, the penalties would depend on whether the plaintiff is successful in the lawsuit, and that would depend on basically the court's discretion as far as what those penalties could be. They're typically monetary damages are the penalties, but the amount of those damages depends. And then if filing a complaint with the Department of Justice, or the Arizona Attorney General's office, if either one of those complaints go into mediation, it would be a negotiated settlement as far as what the parties decide the penalty should be.
Okay, thanks. Scott Hyder brings up a question, something that's recently been in the news, where there was, I believe it was an attorney or a law firm that was going around and suing businesses for ADA violations and filing complaints and trying to get settlement money. Is that still going on?
So it's not going on in Arizona, because Arizona actually passed a law that before filing a lawsuit against public accommodation under the Arizona version of the ADA, first a demand letter has to be sent to the public accommodation, and 90 days have to be given to the public accommodation to rectify that violation before a state lawsuit is filed. So we're not seeing that happen in Arizona really anymore since that legislation passed. And it may still happen, but my answer to those types of lawsuits are, I mean, there are things in there are provisions in the rules of civil procedures, as well as the rules of professional conduct as regarding not filing frivolous litigation. So I think there are incentives against an attorney doing that, including the possibility of sanctions. Yeah, in my personal opinion, I don't think it's as large of a problem as has been portrayed by certain media as well as defense attorneys.
Okay. I had a question. I know a lot of attorneys that work out of their homes will sometimes meet clients off-site. Do you have any tips or suggestions for people that are going to meet someone, at a coffee shop or a library or something like that, that they can look for, or how they can figure out if the place that they're meeting is allowable under the ADA?
So public accommodations are required to comply with ADA. So if you're meeting a client in a coffee shop, for example, the requirement is that coffee shop comply with the ADA. I think it's always helpful, like a Starbucks or something like that is going to be accessible almost always because they're a large corporation. But if you're meeting at a small business, a restaurant or a coffee shop, just calling them and asking them if they are wheelchair accessible, and if they have places to sit that are wheelchair accessible. I think that's always good best practice. Calling ahead of time and making sure that the place is accessible. But outside of the ADA, I think there are confidentiality issues. I think that we all need to be cognizant of as well when meeting in a public place. But yeah, if it's a library or a business that's a pretty large business, you can it's a safe bet they'll be accessible. But if it's a small business, you may want to just give them a call beforehand.
Are there any other questions?
Well, Asim and Scott, thank you very, very much for this program, so that all of you, to remind you, it is being recorded. It is available on the ACBC website under resources. It'll be posted probably by Monday. And that, along with many, many others, So we have some that are solely for the members, but then we have a whole lot that are for everybody else. Your CLE certificate has been posted a couple of times now on the chat. If you're unable to get it, just email admin@acbcforum.org, and we'll be more than happy to send you a copy. Make sure that, well, everybody seems to have signed on with their name, so that's a non-issue. So again, thank you so very much, Asim. This was a great program. We're seeing some wonderful comments. So we appreciate it. Anybody else have any closing comments? All right. Not hearing any. Everybody take care and have a wonderful weekend. Bye.
Thanks, Asim.